want to use this opportunity to beg APC. Say all those videos where they talk say wanna not do well.
Not do well.
Yes. Now we wanna don't win for tribunal. Our eye don't clear. So that's why we come today to tell Una say we are just getting started.
We bring it back again.
The remix. now this thing be the one make we just dey like this, the one waiting. I beauty say we not get from mind since talk say the judges go do am like this, the case na like this it go be.
Like say we don't know now.
Beauty say we believe like that before. We just talk say make we know whether Nigeria don't change, whether miracle go happen for that time. This is just our family. That the one that they carry for mind talk say you know the work. Now be this, you know the work you through.
When I first say they go televise and live.
I can say, are you serious?
I didn't know. I didn't start to be suspect them. Say they won't explain to us
why you need to. Yeah, man, now we just dey like this the morning. Say, how this thing don't hit us. Hit waiting. We went down plan from the beginning where INEC declare. Plan ourselves, talk say, okay, we know say shege they come. On a plan on our own shege.
And even the suspect say, piece of people don't write the one way they carry goes Supreme Court. You don't file and keep.
A guy,
I tell you wait.
Like you don't file Supreme Courts now. When he tell you say, I will fight this thing to the end. He not be saying na tribunal. He not say tribunal. No go give up. With that in tiny voice, I am with you. Just know that I know it's going to take time. It is say if he no say tribunal go give him, he go tell you say it go take time. It's going to take time because I know how it's going to be. The country we are getting it back, not before tribunal. As he instruct all the in lawyers say head Supreme Court. APC people touch. Hi, this man, waiting be this. Waiting they won't hear from the man talk say, okay, I give up. You people have won in the tribunal. I give up. Say that they go to judge. As Peter Obi talk say, I am not satisfied with the judgment from the tribunal. We are heading to Supreme Court. BC talk say, oh God, not again.
Imagine you as a judge. when he thought that thing.
What the hell, God?
This man will be rest.
I tell you now, when I find person where we go collect a mandate. Nah, trader on the chama where they are on the chama person when they do trader for my market. He go pursue you reach head bridge. Come, customer, you forgot to buy that 20 naira something that you priced. Whatever you price, you buy. Now they talk say make you leave you like that. If you say they even do the judgment, make you first small.
Say they respect some of the judgments.
Okay, as you talk say Abuja now, not Abuja and other states.
And other states.
Waiting be the capital of Abuja. Okay, if you be that Gwagwalada, let me make this guy the singer. Abuja, Gwagwalada.
Abuja be like other states.
He said Abuja be like other states. 37 states and capital. Abuja, Gwagwalada. I do always scatter my head while I talk say, what is going on here? And I talk say, the account where they talk say it forfeits money, where they put money, maybe that's drug money. Say, no be Tinubu commit the crime, say na in your account. So NDLA they do illegal work all this while. When they go person land, we get Igbo. Arrest the person we get her. Why they no go arrest land?
They arrest the person like no, they go arrest Igbo, leave the person.
The person go tell them, now my land. but not me do am.
They say na for fit. Na for fit, not a conviction.
Not even say na for fit. I say even if say na crime, say US no ban am to enter US. Therefore, it's no longer a crime. So this kind of judgment that you go give finish, you will call tell P2B, say make it tell you say I am satisfied with the judgment. First of all, not satisfied with the election, when they satisfied with this kind of judgment. It is not possible. Look, let me tell you, my respected elder brothers in the tribunal, I respect you very much. You are giving your judgment, and I saw it. Thank you very much. I respect you. Thank you very much. But let me tell you.
And that respect not dependent.
Why would they respect him? What's P2B tell you?
Just did judgment against him.
Why is he respecting us? We beg you for respect. What's P2B tell you? Say I respect you very much. Just respect. Say wait till they go. I respect you very much, but like I said, like I always said, you see, the person you put there is not the person that is supposed to be there. You saw the judgment. How can you tell me that I should bring the polling unit of every place they rigged something? Am I a police? Look, Tribuna, you cannot come through the window and start cleaning the house. Mamma mia!
Yesterday, 6th of September 2023, the Presidential Election Petition Court, DEPC, finally delivered its long-awaited judgments on petitions challenging the outcome of the presidential election held on 25th of February 2023. This judgment was delivered within the statutory time frame under the extant status. We acknowledge the court's contributions to due process and seeming attempt to strengthen our democracy. As petitioners in this case, we respect the views and ruling of the court, but we disagree with the court's reasoning and conclusions in the judgment it delivered. It is my intention as the presidential candidate and the intention of Labour Party to challenge this judgment by way of appeal immediately as allowed by the Constitution of the Federal Republic of Nigeria. The PEPC has rendered its judgment, but that esteemed body is not the final arbiter. The responsibility now falls on the Supreme Court. I do know that the judgment is not conterminous with justice. I implore Nigerians to remain focused, steadfast, and peaceful, and to abide by the rule of law and understand this matter has not reached its logical conclusion. Our legal team has already received our firm instruction to file an appeal against the decision. I shall not relent in quest for justice, not necessarily for myself, but for indeed for our teeming supporters all over Nigeria, whose mandate to us at the post was regrettably truncated by INEC. The strength and value of our democracy reside on solid national institutions and our confidence in them. Electoral litigations will almost be unnecessary and non-existent if the Independent National Electoral Commission discharges its statutory functions creditably, transparently, and with tenable fairness. When that body fails, as it did recently, thus subverting the will of Nigerian voters, the recourse to judiciary becomes imperative, as is now the case. I thank every Nigerian who has supported our cause and campaign for a new Nigeria, characterized by fairness, equity, justice, rule of law, peace, prosperity, inclusiveness, sustainable growth and development. A new Nigeria is possible and achievable. I especially thank our legal team, the Labour Party and the Obedient family, and all those who showed up daily during our court trials. God bless you all, and God bless the Federal Republic of Nigeria. Thank you.
Good morning, and thank you for coming on today.
My pleasure.
Well, before we even go in and take a look at some parts of that, the judgment, highlights of the judgment, yesterday was, nobody saw that coming. I mean, regular people thought, well, maybe they start and in 2, 3, okay, maybe max 4 hours. Some stretched it and said, okay, 5 hours, we should be wrapped up, done, pack your bags, everybody go home. But no way. At 10 p.m. last night, they were just, I think they wrapped up at about that time, and then just giving the usual conclusions, statements from lawyers and things like that. But how do you see why it took that long, first and foremost?
Well, let's say that it was a marathon judgment. They wanted to exhaust and clarify all the issues so that nobody will say that the judgment left any issue in context, not resolving it or not taking a position on it. So they went into the minute details, and then everybody had to read his opinion. And at the end of the day, that's why it took so long. But I think for people of that age, both the judges and the lawyers, there was a need for not just a 15-minute break, but that when people got tired, they would go out and stretch their legs. There could have been 1 hour in between. These are the kind of things that the doctors will tell you will possibly lead to some health challenges for people at that level, that age. We're not discussing young men and women 15, 20, 30. We're discussing men in their 60s and maybe 70s. So I think going up in future, they should be able to see how to break these things down, in such a way that maybe you could take some to them, maybe the following day you take the others.
And then there was also that thought, wondering, so when they broke all of these things down, as you also describe it, what more can the Supreme Court do? Because if it's really this clear, many just wonder, it doesn't make it, somewhat easier for Supreme Court to decide upon it.
They have taken their positions on these issues. And many Nigerians do not agree, and legal practitioners, with their position. So it makes it easier for those who felt shortchanged by the judgment to look at the facts, look at the law, and then lodge the proper appeal at the Supreme Court for them to have the final say. So it even makes it easier for the appellants to find out exactly what they're complaining against and then present it before the court. It will even make the work of the Supreme Court easier.
We also had Chris Uchesi and demanding for the judgments.
Certified true copy.
Yeah, yes. that day.
Yes.
So that because that time.
Yeah, that time. Between now and 60 days, the Supreme Court must give his judgment. And the earlier you go before the court so that they start looking at the materials, the better.
What did you think about the live coverage?
Well, if you recall that at the beginning of the proceedings, some Nigerians had demanded that they wanted to have live coverage of the tribunal proceedings to get a blow-by-blow account of what is happening, how evidence is admitted or rejected, or how they have been interacting with the parties before them. But they turned it down that it's not a comedy session, it's not a drama session. So some of us are wondering what actually changed when it came to the time of the judgment. Because if you understand the law properly, when a court is trying a case, particularly a case of such national significance and importance as this, the court is also on trial. It is the prerogative of reasonable men and women to sit back and decide to watch even the demeanor of the judges and how they are performing their judicial duties, as to form their own opinion whether justice is being done, because the justice is not just what you did on the last day. It's a continuous exercise. What you did on the first day built up into the second day until you were ready to read the judgment. So some of us were wondering what exactly changed between that first request, which was turned down, and this one, which on the court on its own, so much, the court, there was nobody who applied. The court on its own now said, everybody should come. Everybody should watch. We are ready to read the judgment. So I thought that they would have allowed this live proceedings from the beginning of the case up to the conclusion.
Because many say, look, why is it that Nigerian judiciary took this stance? And for instance, in several countries across the world, several high-profile cases, they see what transpires, blow-by-blow account, they see the faces of the judges. But in this case, we don't see their faces.
Even yesterday, I hardly saw the face of any judge. I don't know if I'm right or wrong.
You're very right. That was a directive. That
yes, nobody.
Just
so what exactly were they hiding? You know, there are things that raises questions. These are Nigerians. Many lawyers know them. Many people know them. What exactly were they hiding to say, don't put the camera? Because even the idea of you hearing a voice without seeing the person, the reading, the face, the gesticulations, even the way the person looks, makes it look somehow like an artificial intelligence kind of proceeding. There was absolutely no reason why we shouldn't have seen them. And nobody, there was no provision of the law, no rules of court that said that their faces should be hidden. I mean, why do you have to hide if you know you are doing the right thing? So some of these things were questions agitating the minds of some Nigerians yesterday.
Okay, so to some of the highlights now. So yesterday, many thought, will there be one dissenting voice, two dissenting voices, but they were disappointed. And then the highlight, the consolidated petitions, all dismissed. And the way and manner that it came through as well is what several reactions, 25% votes in the FCT, not compulsory to have that. Shatima validly nominated, even Itobe himself validly nominated by the Labour Party. So virtually no case submission.
Well, what happened yesterday did not start yesterday. It's a culmination of the understanding of the jurisprudence of electoral dispute adjudication from the Obasanjo days. The courts have been doing it up till yesterday. Now, I say with utmost respect that why we will continue, or why these kind of decisions are coming from the courts, is that the courts have failed to ask a simple question. What is the purpose? What is the goal of electoral dispute adjudication? If I may provide an answer, it is to determine who actually got the majority of the lawful votes from the electorate. Since Section 1, Subsection 2 of the Constitution says the Constitution is supreme, nobody should take control of the whole federation or any part thereof in a way and manner not in accordance with the provisions of this Constitution, which means you can only lead or purport to lead by virtue of the votes. But that hasn't been happening. What has been happening is that the judges, not just this panel alone, usually go what I call a wild goose chase, put adjectival law, put all kinds of challenges and obstacles on the road. So they are not actually trying to determine who won, but it's like who can display more of the knowledge of legal technicalities and gymnastics. Let's look at this way. The petitioners went to court. For the first 2 to 3 weeks, the court gave an order to INEC to provide them, give them access to beavers and materials. It took almost 2 to 3 weeks before they could have access. And they didn't have more than a couple of days before INEC came back with an application they want to wipe out because they have to use the machine for another election. If you recall, in so many states of the Federation, the INEC put obstacles on the way of petitioners to access the materials and information they need. Now you put the whole blame, the whole onus, because hearing the judgment yesterday, the recurring decimal was the petitioner failed, the petitioner failed. At some point, it was sounding like a rebuke to the petitioner for coming to court in the first place. All right? Now, if you are presuming regularity from a government agency like INEC, and it has been shown to you that there was nothing regular about what they have done. They uploaded materials on the net, and you have materials from Katsina in Port Harcourt or in Abia, you have from Abia in Maiduguri, all those kind of things. That rebuts that presumption of regularity. It should be up to the commission to show why it has to be believed. You put everything on a petitioner. Just a political party leader, and he's not part of INEC, he's not part of the police, he's not part of the law enforcement agencies, you now want him to also prove. For instance, INEC put up a portal. They also manipulated the portal. And you want the petitioners to prove how INEC manipulated the portal. It is up to INEC to come forward with credible evidence that a portal, which they told Nigerians was the game changer, suddenly went off for a few hours and resumed the following day. And the few hours it went off were the critical hours when it had to be relied upon. You also said nobody can force INEC to electronically transmit the result. Did anybody intend to force INEC? INEC came out with regulations. And we are the ones who asked the National Assembly to give them money, public money, my tax money, my honest sweat. And it was given to them. They built up a portal and regaled Nigerians at various fora, from Mr. Yakubu to Festus Okoye to all of them, both within Nigeria and outside, about the game changer they had. And at the critical moment, they failed. And you are saying nobody can force them. Did anybody intend to force them? They made a promise, spent taxpayers' money, and failed. And instead of rebuking them, you are rebuking a petitioner who says, I relied on what my government official who took my taxpayers' money and blew it in the air did. But how can you be hard to say that? So it's a proper misdirection, because you get people who call themselves senior advocates try to dance around these things. Why is Nigeria perpetually a toddler? Why are we not making progress? In 2015, the card reader issue came up, right? And the Supreme Court said, oh, it's not in the law, it's not this one. When you have a mischief in the law which has been identified, you recall the Saraki Senate even amended the Electoral Act which Buhari didn't want to sign. Even the Senate and the House did. It was at the last minute that he was forced by public opinion to sign. These amendments, some of them, we are meant to cure the mischief that were discovered close to 10 years, 5, 7, 8, 10 years ago. And we are still repeating the same thing, we don't learn from our mistakes if they were mistakes, making me to believe that these things were deliberately planned and have the courts affirm them. And then what message are we sending? What message?
You know, when you say that, was anybody trying to force INEC to prove or to upload?
Upload, yeah.
But what about when, I mean, you all say that he who alleges must prove, and the lawyers know it. So isn't that a similar scenario that if you're going to court to say INEC didn't do this, you must be ready to prove your case?
Sorry. There are facts peculiarly within the knowledge of an individual or an institution. And in law, those facts, the onus is on the person to come and give evidence on why he shouldn't be held, that this thing should proceed in the normal course of things. You built a portal, or you commissioned experts to build a portal. When they finished, they reported to you. You were given the back end, the passwords. Your own IT technicians are the ones who are now in charge. The person who built it has gone. All right? And you made a promise to everybody, uncoerced. It's not like anybody forced you. You came out in public and said this is a game changer. So when you did not deliver, should I have the onus to show why you did not deliver? When I don't have access to the engine room, the back end, the passwords, and anything, it is you who should come and tell us. And don't tell us things that don't make sense. Oh, you had a glitch. What is a glitch? You shut down a system, you say it's a glitch.
So on the flip side of this, listening to all of that judgment too, and then, of course, people will interpret certain things differently. But doesn't this also suggest that for some, they think, okay, well, if this is the judgment and how it has come down, are they trying to also say, well, there are several loopholes in the laws. So if you don't want this to repeat itself, let us go back and correct our laws and be more specific about who needs to do what, particularly INEC, moving forward.
Yes, we have always had this idea of a new electoral act after every election. But this thing is beyond putting things down in a law. It's about a mindset. Because the way these judgments are proceeding to say, oh, show me where it is in the law, it gets to a stage, Chamberlain, where you'll be asked to show where it is in the law that you must eat. or that after 2, 3, 4, 5 hours, you can visit the bathroom. It's about the mindset of the operatives, rather than saying, because you will end up with a 1,000-page piece of paper, right, called a law, which will be passed by a National Assembly and signed. But we live in a normal human society where you cannot anticipate all the issues and challenges that will come up. And somebody must always take advantage. Why are we always taking advantage to game the system? Okay? You say it is not in the law. What exactly, on what basis did INEC collect this money? Taxpayers' money. Blew it up unapologetically. Stop the parties from gaining proper access to the records they need. And all we hear, the judges who even gave the order, never at any time were angry enough to try to cite INEC officials for contempt. They were playing on. Nothing was wrong. So we can't make progress based on this. You see, let me explain to you. We all went studied law, went to the university, read jurisprudence, read evidence, read adjectival law. The truth is that any position you want to take in law, you can find a justification. Whether it is justice, whether it is about what the people expect of you. Listen carefully. Judges are public servants like every other person. They are supposed to interpret the law, not in a vacuum, to advance society. Otherwise, why were we blaming military dictators who made laws, okay, that we did not like? If we go on just this rabid positivism, oh, show me where it is written. Buhari, the former president who handed over to him, shot people because they were involved in drugs. And the trial, nobody can even verify whether it was a proper fair trial under those military decrees. And before we could say Jack, he killed them. Now we have a situation. The Constitution never anticipated that somebody who will be nominated by a political party will have a history of forfeiting money based on involvement in drug proceedings.
It's a civil matter.
No. It's not about that. Now, official proceedings are not civil matters per se. They are a hybrid between civil and criminal matters. Okay, look at the Desiani case we have in Nigeria. You are suspecting, the government says, this money we found in your account or this property is beyond your lawful and legitimate income. Come and show us it must have been the proceed of an unlawful activity, a crime.
So the character
come and show us how you got it. They do an interim order, which they didn't give you the opportunity to come. They now advertise and invite you to come and show how you legitimately got this money. And if once you're unable to do that, the court now says this must be the process of crime or illegality. And so the money is forfeited. So to tell me that it's simple civil proceedings is reading the law upside down. We all went to school. The fact that you became a judge doesn't, yes, you have a duty to perform, you have the authority, but it doesn't give you any special learning to turn very simple, straightforward things. Let me tell you something. Whenever you see a professional becoming extremely technical, speaking highfalutin Latinate jargons, is a sign that he doesn't understand his duty, because whatever you can say and whatever you want to express can be done in simple is and was that doesn't bewilder.
It's not legal jargon.
It doesn't need to bewilder anybody, because everybody's bewildered as how a man who could not contest the forfeiture of his $460,000, and you say there is no blame. He says you must be arraigned, you must this. Why did he not contest that? The Constitution didn't anticipate that kind of thing, that a man will be the president of Nigeria with what? Nobody knows when he was born, conflicting documents. Nobody knows the schools he attended, conflicting. No, we can't continue behaving like that. When you get to the international airport, they say Nigerians this way. Step aside. You complain. How did you arrive at that thing? So this is beyond just abstruse legalism. Okay? The petitioner failed. The petitioner failed. As if to say all we are coming was like the petitioners had to